behaviour, particularly ones which cause problems across borders, like terrorism, drug smuggling, money laundering, child pornography. These instruments require the member states all to have criminal laws punishing these things and to have maximum sentences which are of at least a certain degree of severity. And then lastly, there are some instruments trying to harmonise criminal procedure by requiring the member states to ensure their criminal procedure does various things like respect victims' rights in certain ways and provide certain minimum rights for defendants. And the aim of this is to try to reinforce mutual recognition by ensuring that the courts of the different member states have confidence in the qualities of justice in the other member states whose orders and judgments they're expected to enforce. The Luxembourg court system, as of December 2014, now has a measure of jurisdiction over all this, but it's quite limited. It can have infringements proceedings brought against member states that fail to carry out their obligations. Not much of a threat to the UK, which has a good record of implementing its international obligations and its European obligations, which is one of the reasons why the UK is rather cautious about letting itself in for these obligations. And it can also entertain preliminary references from our courts. So if one of our courts has a question that arises as to the compatibility of some piece of national legislation with a European instrument, it can ask the Luxembourg court what the position is and should be and ask it for directions. And contrary to what some people think, Luxembourg isn't a further round of appeal in criminal cases, particularly for unmeritorious defendants.
So why are we so exercised by all of this?
I think we're exercised by it because a lot of people have got completely hold of the wrong end of the stick about what EU criminal law is about. As I've explained it, most of it is about trying to ensure that the justice systems of the member states, the different justice systems of the different member states, work to some degree step in step to deal with crimes and problems which operate across borders. And there's absolutely no question of there being a kind of Brussels plot to enforce the UK to give up the common law, as is internalised by UKIP and by quite a large section of the Conservative Party as well.
And what might happen to all of this? So if we think that this body of rules is quite important, what might be the consequence of the referendum on that area of regulation?
If the UK left, the result could be that we'd be relieved of the burdens of this legislation insofar as it imposes burdens, and that we would be deprived of the benefits of this legislation insofar as it confers benefits. Would the loss of benefits matter? Well, we have to remember that the purpose of EU criminal law is to deal with the unwanted consequences of free movement of persons, goods, capital, and services, which is a basic element of EU policy and designed to encourage free trade. It's designed to deal with the fifth freedom, the unwanted free movement of criminals and crime, and not having the benefit